You want to have a power of attorney, healthcare proxy, a will, and a disposition of remains appointment. And if you remember back to all of our celebrities, each of those cases gives you the foresight to know that it could happen, and it can happen to any of us, even you. So the power of attorney is a financial document where you appoint agents, people who are going to be able to pay your bills, manage your assets, take care of your Social Security, your IRA, do the things that you would be doing for yourself if you're unable to do them. And even for married couples, it is critical that one spouse appoints the other as power of attorney, because even though a lot of spouses sign their name of their other spouse, and they get it very good too, they learn that signature and they know how to sign the checks, but that's not legal unless you have a power of attorney. And then you would appoint others, alternate agents. You can have more than one agent. So you can have 2, 3, 4. If you have 3 kids, you can name all 3 children. If you really want to screw up their lives, make them agree on everything and act together. Or you can have them act separately. You get a lot of flexibility in designing the document. In New York, our statutory short form power of attorney is 16 pages. That's the short form. And it has something called a gifting rider at the end. That gifting rider is critical if you need someone else to do planning for you. So if you have the power of attorney, but you haven't done the gifting rider, and we have these cases come through our office all the time, people either downloaded the document off the internet, or they used LegalZoom, or they had somebody hand them a power of attorney form that's old, and they didn't fill it out properly. It happens all the time. And the most common mistake is not doing the gift rider. So if you have a need for planning and moving assets into trusts and making gifts and doing credit shelter or asset protection planning, you can't do it without that gifting rider. So you want to make sure you have the power of attorney done right. Have it done by a professional, someone who knows the ins and outs of the power of attorney and what it does. And if you have it done right, most of those guardianship issues dealing with your property can be obviated. You don't need the courts to do what a power of attorney can do for you. That's the financial side. And when we go to court and petition for guardianship, we may petition for a guardian of the property. We may also petition for a guardian of the person if they don't have healthcare decision makers in place. So a very basic document, but it has a lot of nuances, is the healthcare proxy. You want to appoint an agent. In this case, it's only one, a single agent at a time. And you can appoint alternates. We always want to have backups in case the primary agent is no longer available for you. When you do a healthcare proxy, you also may want to do a living will. Some attorneys do that as a separate document. In our office, we incorporate the living will provisions into the healthcare proxy document. So you have a single document that appoints your agent and then provides excuse me, your instructions. And primarily the instructions are for end of life issues. Remember Terry Schiavo? Would she have wanted to be kept in that persistent vegetative state by artificial means for her whole life? She could have lived another 20, 30 years in that condition. Is that where you want to be? If it is, you believe in miracles, and we do have clients that do, and we will put that language in the document. Then you want to have your specific wishes carried out. For most of our clients, they want to say, if there's a hope that I'm going to get better, if there's any reasonable hope, and I have any quality of life, then keep me alive. But if I have no hope of recovery and my quality of life is gone and I'm being kept alive by artificial means, allow those to be withdrawn. So you need to be very specific in this. There's a MOLST form that is in New York State that many people do. They've always done them primarily in hospitals and nursing homes, but more people are now getting to do them with their primary care physicians. And this is a medical order. So it's not just a lawyer's document, which is the healthcare proxy. It's a medical order done by a medical professional for life-sustaining treatment. And the MOLST form is several pages, and you go through very specific scenarios, and it's best done with your primary care physician. But it's something, if you're interested, ask your doctor next time you have your annual checkup, say, I want to talk about a MOLST, and they now can do that. And they actually have a billing code under Medicare and most insurance policies to talk to you about that. The do not resuscitate order, or DNR, most people that I talk to do not want, even though they hear it and say, well, I want a DNR. They confuse it with a living will and healthcare proxy. If you're a healthy individual and you code and your heart stops, but I could put paddles on you, bring you back, and you could come back to a normal quality of life, would you want me to do that? And for most people, the answer is yes. And if the answer is yes, you do not want a do not resuscitate order, because that would prohibit me from trying to bring you back. If you're at a stage in life where you do not want to be brought back, if you code, you don't want any extraordinary measures taken, you don't want the paddles put on you, then you do want a DNR. And at some point, that may be true, but don't do it prematurely if you think you want to stay alive and could come back from an event like that and go back to a normal, or at least a relatively normal quality of life. So you have the healthcare proxy and living will. We incorporate them in one document. You always want to have good instructions to your agent. Everyone should have that. Consider a MOLST if you want to go to the next level and do it with your physician. And if you're at that point in life that says, you know, if God wants to take me, I'm ready, then the DNR order may be appropriate for you. But in most cases, I found that it's not. So those are our medical directives. The last one here in this string of documents, it's called the disposition of remains appointment. And think of poor Ted Williams. And there's a whole book written about his experience, and it's gory and it is creepy. But you never want to be in a position where you didn't want to be. So you can appoint the person that you want to make final arrangements for you, and you can then give them instructions. Again, we one at a time, like the healthcare proxy, but we want to put alternates in the document so that you have a succession of decision makers for you. Who is going to make that final decision, deal with the funeral director, deal with the claiming of body? Not pleasant things, but I've been through it with both of my parents, and I would have loved to have some direction from them as to what they wanted. We had to kind of figure out what they wanted on our own. And I've had many, many families come back and say, if I didn't have that document, I would never have known what dad or mom wanted, and never would have followed their wishes that they articulated in this document for me as the child. So it's a gift to your family. Lay it out, make it clear, put your wishes in there. Many clients now want to be cremated. And if you want to be cremated, you should state that specifically. How do you want your ashes disposed of? We have some exotic plans where people are in multiple locations and parties are being thrown all over the place, Ireland, in different places. So you can put all of that into this document. And in New York State, not in every state, in New York State, this is a legally binding document that will bind your agent and the providers to follow your wishes. So good thing to have in your arsenal again. And then finally, a will. I mentioned earlier that a will appoints an executor and a trustee if you are creating trusts in the document. It also disposes of your property. So I want my bank accounts or everything liquidated and divided up 3 ways, or I want specific things, my jewelry to go to my daughter. All of that goes into the will. If you have minor kids, you're going to appoint a guardian here. And if you want to create trusts for your children, you're going to create the trusts here. And every will can be done clearly. It can be very effective, but it has to go through court. If you probate and you have minor or disabled beneficiaries, the court's going to appoint something called a guardian ad litem, which is another attorney who's going to get involved in addition to your legal team. And they're going to do an investigation of the will and the estate and then come back and file a report with the court. A lot of formal procedures that are required in probate. We do a ton of probate work. Some of it goes very smoothly, some of it doesn't. But all of it is very time consuming, and it's more costly and expensive than it needs to be. So when you compare using a will versus using a trust, the trust does not have to go to probate. It's free of court supervision, both during your own probate and for any trusts that you create in the future. If you create trusts for your children under a will, they're under ongoing court supervision. So they stay in the court system if they're called testamentary trusts. And with a trust, you don't have the delays. Your successor trustees are going to be able to step in, manage the trust, deal with your assets immediately without court intervention and without having to serve any of your other beneficiaries. When you go to court for a probate and you have people maybe you've cut out of your will, or you don't want to have notice of the proceedings, if they're distributees, if they would have taken anything but for the will, they all have to either sign a waiver or be served with legal process called a citation. And that's where you really get caught up. It gets very thorny when you get into a citation return date, and beneficiaries can simply appear and say, well, I'm cut out of the will, I object, I want to have a hearing, and they get a hearing. So the probate process we can avoid with trusts, and we have a variety of different types of trusts. We're talking now primarily about living trusts versus the trusts created under the will, which have to go through probate. A living trust is done now. It's a living, breathing document, and it gets a current identity with a trustee, a beneficiary, and you as the grantor creating the trust. So it's a contract among those three parties. You put your money into the trust, the trustee manages it for you, and then you have beneficiaries that are going to be benefited from it. Trusts can be done for a variety of purposes. We're going to talk about the revocable trust, which is the most common type, but then there are irrevocable trusts that are done primarily to protect assets. We'll talk a little bit about why you want to protect assets, and to do tax planning. And we're going to talk about the tax motivated trusts at the next session, but let's take a look at some of our most common trusts, and let's do a brief poll. So if we could get to our polling question. The biggest mistakes made when creating a trust, and as an attorney that sees a lot of trusts done in other places, there is a Susie Ormond video where you can create your own trust. There is LegalZoom. We see a lot of those documents where people come in and ask us to review them. What are the most common mistakes? Forgetting to name contingent beneficiaries, not naming a successor trustee, failing to properly fund the trust, or failure to change the trust when circumstances change. And you can choose more than one of these answers. And our survey says, failure to change the trust when circumstances change. That is a good one. And that does happen frequently. One that a lot of people got right, 35%, but 65% did not, is failure to fund the trust. When we create a trust in our law firm, we make sure that our clients transfer their deeds, their bank accounts, their stocks and bonds, their life insurance policies, their annuities, their business interests. All of those things have to be retitled into the name of the trust. The most common error we see at the creation of a trust isn't the design of the trust, although some people don't design it properly and don't put enough contingencies in. It's failing to put your assets in. Once the trust is created and circumstances change, then you get to the fourth answer, failing to change the trust when things are different down the road. So thank you for answering the poll. We're going to move on to our next slide. Once I get slide control. There we are. So let's start with the revocable trust. And again, it's an agreement among a grantor. Well, in a revocable trust, whose assets are going in? Let's say they're yours. You put your assets into the trust. In a revocable trust, who is the trustee? Well, you are, because you can be the trustee of your own trust, which means that you don't give up any element of control. This is amendable, revocable. You can change it or revoke it at any time. You're managing things on your own behalf, so you are also the beneficiary. You can put other beneficiaries in, but you are the primary beneficiary of your own revocable trust. Well, if I'm the grantor and I'm the trustee and I'm the beneficiary, why would I even use a revocable living trust? And the answer is two main themes. One is during your lifetime, remember the probate on one side and the guardianship on the other? If you lose capacity and your assets are in trust, you've appointed successor trustees, you have also given them terms of the trust. You have laid the track for them to follow. So the successor trustee simply gets behind the wheel of the train and follows the track that you've been following while you were your own trustee. They may benefit a spouse with the trust. They may benefit children, grandchildren, disabled children. All of those provisions go into the trust. So you are in effect, even during a time of incapacity, determining how the trust assets are invested and how the trust funds are utilized for your benefit and for the benefit of your other beneficiaries. Upon your passing, if you're still the trustee of your trust at that time, you're simply going to step in and have your successor come in and be the next trustee, again, following the track that you have created. So all of your assets follow through with that. The trustee has immediate access to them, doesn't have to wait for the judge to review it and issue an order and issue certificates of letters testamentary. They can manage your business, manage your real estate, pay your bills, take control of your assets. If the market's tumbling, they have immediate access and control, and they can make sure that your investments are being managed and dealt with correctly. If you have a brokerage account that goes through probate and it's delayed, no one trades the account. It's frozen. All of your assets are frozen through probate. The trust avoids all of that. And those two scenarios, your incapacity and your death, are the two primary reasons that a revocable living trust gives you enormous advantages over the will. And if you had a will, you would be relying on the power of attorney during your lifetime. So one of the shortcomings of a revocable trust is if you did want to protect your assets. And many of our clients come to us today and say, well, you know, I'm okay. I have a pension, I have Social Security, I'm okay in terms of my planning. But if I need long-term care, if I have to go to a nursing home, or if I need care in my home, or if I need assisted living, the cost of that care now in the capital region and right in Columbia County, it's about $15,000 per month. And you don't have to be a genius to do the math. You're talking about $180,000 per year. If your income can bite that and take a big chunk out of it, fine. Then you're pretty much self-insured. But if you're short of $180,000 a year of income, then your assets are at risk. And when we look at long-term care planning, we look at the ability to self-insure. And for nursing home care, that's $180,000 per year. For home health care, it could be much less, or it could actually be more if you require 24-hour care and you go to an agency and you say, I need eight hours a day, 3 shifts, 24 hours a day care. You're going to pay about $250,000 for that. Those agencies are charging $25, $30, $32 an hour. And if you do the math, 365 days, 24 hours a day, about $250,000 a year for 24/7 home health care. What can you do in advance? How can you plan to put that kind of protection in your estate and financial plan to make sure that if you do need the long-term care, you're not going to be belly up, that your assets are not going to be depleted? And we are very fond of insurance products that will cover long-term care. They have taken some hits because the prices and the premiums have gone up, but there are still some very viable products in the long-term care market. And if you are in your 50s or 60s or 40s, then long-term care insurance is going to be a good option for you to consider. Life insurance products are now very creatively designed to allow you to actually use the death benefit of life insurance early to pay for long-term care. Some wonderful products in that market. But if you don't have that insurance in place, by the time you're in your 70s, then you're not going to be able to buy it. It's going to be prohibitively expensive, and most companies don't go now beyond age 75. So what do you do in that case? Or what do you do if you have a pre-existing health condition and you can't buy long-term care insurance? Or what if you're at a point where the premiums are unaffordable based upon your income? And this is where there's a word on the screen, Medicaid, that you should not confuse with Medicare. Medicare, everyone gets when they're 65. And Medicare is an entitlement that came in at the same point in time as Medicaid, 1965, part of the Lyndon Johnson Great Society program. And the preamble to Medicare said, never again will seniors in America have to worry about health care. Well, Medicare is falling a bit short on that, and Medicare does not pay for nursing homes other than when you go in from a skilled care stay. It has a 100-day short-term benefit. Most of our clients get about 20 days out of that. Beyond that, you're on your own. And Medicare doesn't pay really for any significant amounts of home health care either. Again, you're on your own. If you want assisted living, it's not going to pay. Medicaid is the program that does pay for home health care and nursing home care and certain amounts of limited assisted living care. But Medicaid is a means-tested program. So Medicare does not cover this. Medicaid does. But in order to get Medicaid, you must meet strict financial criteria. So what are the Medicaid numbers? If you want to get Medicaid, these are confusing, so I'm going to go through them quickly, but I'll highlight what's really relevant. If you're a single individual and you want Medicaid, whether you're at home or you're in a nursing home, you can only keep $15,900 of total assets. Most people say, well, I would never need Medicaid. I have money, I have assets, I have income. $180,000 a year. Is that something that your estate can bear? And if it is, again, you may be self-insured. But there's a wide swath of people and a broadening swath because of the escalating cost of care that can't afford to pay that freight for very long. So Medicaid becomes a program that you have to rely on. And in New York, we pay a lot of taxes, we get benefits. Medicaid is one of them. Medicaid home care in New York pays a very rich bundle of benefits. And $15,900 is what you have to get your assets down to. If you're at home, you have to get your income down to $904 per month. How many of you could live on $904 per month? Now, maybe if you lived in Hudson back in the 70s, you could find an apartment and be able to live for that. But in Hudson today, you're not finding anything for $900 a month. So how do you pay your rent? How do you pay your bills? How do you get to utilize the rest of your income and still qualify for Medicaid? And how do you get your assets down to that $15,900 level to qualify for Medicaid? And we refer to that as Medicaid planning. And as with the revocable trust, the solution here is a trust, but this one is going to be irrevocable. Get to that in a moment. Medicaid breaks down generally into two different programs. One pays for nursing home care. We call that the chronic care program. And one pays for home care. That's the community-based program. Medicaid in New York State is undergoing significant changes. Those changes are partly in effect now. Some went into effect October 1st. Other changes have been deferred because of the pandemic. The state cannot whittle Medicaid benefits down during the COVID crisis. It's a federal prohibition. So the back end date has been pushed back from October 1 to July 1. And now we're understanding from the state it may get pushed back a little bit further. But at some point, we're going to have a whole new set of home care rules for Medicaid. I'm not going to get into the weeds tonight. If you want more information on Medicaid, we have a series of webinars coming up. We're calling them Medicaid Mondays in March, and you can watch those and sign up for those on our website, pierrolaw.com. Go to the events tab. But for Medicaid, we have to get down again to a certain level, $15,900 of assets. If you want to give assets away, there's a 5-year look back for nursing home care. Part of the changes for home care is that we now have a 30-month or 2.5-year look back for home care. So any assets gifted after October 1st of 2020 for Medicaid home care purposes are going to generate a penalty. If you can't self-insure, and if you don't have long-term care insurance or a life insurance with that rider that allows you to pay for care and you can't get it, and you need to rely on Medicaid, there is a way that you can do that utilizing another type of trust. It's an irrevocable trust that we refer to as a Medicaid Asset Protection Trust. And this trust you can set up in advance, put your assets in, you were the grantor. One difference is that you would choose other trustees. Most people, if they have children, will choose their children or siblings or nieces, nephews, family members. generally are the people that will serve as trustees of these trusts. And the trusts stay in existence for your lifetime, for the grantor's lifetime. You keep living in your home, you keep using the real estate that's in the trust, you keep the income from the assets, but the assets are in that trust and cannot be given back to you directly. So these are the assets that we typically place and fund, remember the trust funding, into an asset protection trust, home, bank accounts, stocks and bonds, annuities, life insurance, business interests, other real estate. And you get the income from all of those things. You get to use the properties. If you have two homes, you have a vacation home and a main home, you get to use both properties. But for Medicaid purposes, what you place in that trust is no longer considered countable. So you've effectively removed the assets from your taxable, from your, Medicaid estate. You've also removed them from your probate estate. They're going to go on directly to beneficiaries, but during your lifetime, this trust is safe and protected. If you need to get principal out of the trust, not just the income, but the actual principal itself, you can pay principal out to other beneficiaries. Again, usually it's children or other named beneficiaries. And if you get the consent of those beneficiaries, even though the trust is irrevocable in New York State, based upon a statute here, you can actually revoke that irrevocable trust. So clients sometimes have a reluctance to engage in irrevocable trust planning. That irrevocable word is somewhat scary, but here are the things that you can retain in order to keep control. The right to change trustees. So the person you name initially, you could change at any time. The right to change beneficiaries, and the actual right to revoke the trust with the consent of those beneficiaries. So this is asset protection planning for yourself. We have an excellent opportunity to do the asset protection planning for our children. In my case, I have a revocable trust, and each of my 3 children will get their inheritance in a beneficiary controlled trust. And that's what we're talking about here. So when my trust ends, it doesn't just spill the assets out to the kids. It sets up further trusts for each of my children, and they can actually be their own trustee of each trust, yet each trust is fully protected. And as a parent, and if you're a parent out there, what's your number one concern if you have children that are going to get your inherited assets? For me, none of them are married yet. I don't know who they're going to marry. And the spouses could easily get married, divorced, and make a claim against those assets if they're inherited by my child. If they're held in the beneficiary control trust, they're exempt for divorce proceedings, creditor proceedings, litigation, lawsuits, bankruptcies, and Medicaid. My children can be their own trustee, and they can have full use of both income and principal. So if you do have kids and you want to structure their inheritance so that they get it, have control of it, use of it, but it's protected for each of them, this is an excellent opportunity to do that. And you do it right in your own document. It's a sub-trust within your trust or even in your will. Make sure when we're doing trust planning that you look at every asset. And we have a very comprehensive questionnaire that we make available to clients, and you can find it on our website at pierrolaw.com. It's our estate planning questionnaire, and it will elicit for us all of the detailed information that we need to advise you. Do you have an IRA, 401k, 457, 403b plan? Qualified retirement assets get very special treatment. We are going to talk extensively about that in the next session, something called the Secure Act that went into effect last January 1st. And we have to make sure we integrate all of those accounts into your estate planning, your brokerage accounts, your bank accounts. A lot of people try to use transfer on death designations or in trust for designations, things like that. But a trust is a much, much better solution, far more secure, and it can protect the assets during your lifetime. So we're going to go through with you every asset that you have, how it's owned, who the beneficiaries are, and we have a kit that we've prepared that we make available to our clients that walk through the trust funding process and help in getting those assets into the trusts. This is the contents of that trust funding kit. And we make that available to you in advance, but at the time you sign documents, you want to look at every asset that you have. You want to identify the ownership of those assets, and you want to make plans to make sure that you don't fall prey to that one flaw of not having your trust properly funded, not having the assets titled, because at the point in time when you lose capacity or upon your death, this needs to have been done. So keys to the estate plan, keys to the trust plan, make sure you fund it properly. With revocable trusts, pretty much everything goes in. There's no reason to hold an asset out of a revocable trust because remember, it's you. These are your assets. So even cars go in there and other types of personal assets. In an irrevocable trust, we're typically going to be more selective and choose the assets more carefully that we're going to transfer in. In both cases, retirement accounts, we don't change title, but it's critical that we prepare the appropriate beneficiary designations and tie them together with the rest of your estate plan. A lot of people are concerned about collectibles. If you have family collections or art collections or coin collections, these can be dealt with specifically. We assign them into your trust, and then we prepare a memo which would give specific items to specific people, and you can keep that memo. We typically prepare deeds to your real property. We will prepare transfers of business interests like stock in corporations or membership units of limited liability companies, and we put all of that together. We do that part of it, and we work with you. We have a trust funding coordinator, a full-time person here who's a paralegal who assists our clients with this funding process. So many people ask, once I have a plan, I have a will, power of attorney, healthcare proxy, disposition of remains appointment, I've taken the steps of doing a revocable living trust, I've put all my assets in there, when should I review it? And I would say a minimum of every 3 years, you should dust it off. We give our clients a nice cloth envelope with a zipper on it. And I've had clients literally come back after 20 years, and you can tell it's the first time they've ever unzipped the envelope. So you want to review these things about every 3 years, but we have a program that we've instilled for our clients that who want to make sure on an annual basis that they're up to date, that they're versed with all the changes in the law, and that their own personal situation can be accommodated into their plan. So we have something that we call our Professional Advocates Lifetime Maintenance System, or PALMS. And that's a program that we make available to our clients where we take all of your data, we create a private encrypted website for you. Your documents are also stored there. It's spreadsheets, all of your assets and the ownership. So we track it, we meet with you on an annual basis, review your entire plan, and you get telephone time without a bill during the course of the year of up to 2 hours. And the fee for that maintenance plan is $850. I'll give you that one. So let's take our last poll. Now that I've created an estate and trust plan, how do I maximize wealth and minimize tax? Well, I'm a big Kramer fan. So you may want to watch Kramer on CNBC, Mad Money. Pay attention to President Biden's policy plans, of course. Those that he can get through, we'll see where those go. I'll leave it up to my CPA and financial advisor, depends on who they are. Consider charitable giving. We're going to talk about that in the next session because there are great ways to incorporate philanthropy, charitable planning, with different types of trusts and different types of vehicles that you can utilize to enhance your own plan, but also leave a legacy to family and to your favorite charity. And of course, register for our March 25th webinar where we're going to tackle all of these tax planning and changes in the tax law, IRA, 401k, the Secure Act, Biden's proposals, the current Trump tax law, which remember, sunsets automatically in 2025. So the law we have today will not be the law we have in 2026, even without any further action. So there you go. I'm hoping all of you, that 84% have signed up. And we'll take our next slide here. Advanced tax planning, March 25th. All the things that we just discussed. Charitable trust. You can register if you haven't already on our website, or you can register through CMH Foundation. that's us. And we're here. If you have any questions, you can always email us, info@pierrolaw.com. We are available by appointment in Hudson. We're here in Albany full-time and full-time in New York City if you have a place down there. And remember, we're now able to do video conferencing both for initial meetings and document signings. There's our radio show every Saturday morning at 11 a.m. on Talk Radio, WGY, 8:10 a.m., 103.1 FM, and Life Happens, Are You Prepared? We talk about all of these issues. We take callers, live calls on the air, and answer questions about life. With that, I'd like to thank the CMH Foundation for the opportunity to present to you tonight. If we can bring back our hosts.
Hello. Are we going to follow up with questions and answers after this for a bit?
Yep, Beth.
Okay,
All
great.
right.
How did we do?
We have a handful of questions. Really interesting ones, starting with, does cryptocurrency count as an asset that is counted in these processes?
And the answer is yes. And there's a lot. I've gone to seminar after seminar, webinar after webinar on how to plan for cryptocurrency, which is not easy because the ownership of cryptocurrency is very diffuse and it's hard to track down. But yes, it has to be woven into a plan, and you want to make sure all types of property, including other types of digital assets, cryptocurrency. We have a whole program just on digital assets too. You want to make sure you integrate them into your will, integrate them into your trust. The ownership, if you have a trustee, how do you convert ownership of cryptocurrency into a trustee's hands? Very, very difficult to do, but there's documentation now that will assign that cryptocurrency to a trust and give them rights to get it and pursue it. Something that is a great question. And if you believe that Bitcoin is the new gold standard, then you better be ready to deal with cryptocurrency in all of its formats. And that's the future, I think, of our currency systems. If you listen to many prognosticators, and from an estate planning perspective, yes, great question, and something that needs to be addressed in your plan along with your other digital assets.
Can you have multiple irrevocable trusts? Let's say one for each child.
The answer is yes, but typically you don't need to. Depending upon what the purposes are, you can create a single trust that will benefit multiple children. And you can gift into that trust. And you can have the gifts count for each child from a tax perspective. And when we do the trusts that ultimately pass to the children when you're gone, then they will separate out. So if you remember the diagram where you have your own revocable trust or irrevocable trust, you may layer in, if you're doing tax planning, a life insurance trust that's just going to hold life insurance policies. You may do gifting with more sophisticated trusts. We do a lot of high net worth tax planning. And at the end of the day, what you're going to do is kind of divide and conquer and then reunite. So if you have 3 children, all of those trusts will ultimately flow into separate trusts, one for each child that they're going to control. If that's your plan, that's perfectly legitimate. You could have one trust that benefits your entire family. We refer to that one as a family bank trust. And then the kids can co-manage and keep the family wealth in a single pot, if you will, and then use that for the entire family, children, grandchildren, et cetera. And so there's a tremendous amount of latitude and flexibility in the design of these trusts, both during your lifetime and upon your death. So you could have separate irrevocable trusts for each child. You may or may not need that, depending upon what your motives and goals are.
What is the average cost of properly setting up an estate?
Good question. So if you're talking about will planning and doing a comprehensive plan with powers of attorney and healthcare proxies and disposition of remains appointments and a good will that has contingencies in it with contingent trusts for minors and people with disabilities and things like that, you're generally looking at somewhere around $1,000 for a well-constructed plan. If you're getting up to trust planning, because you're doing the trust and it's alive now, you're doing all of the asset transfers now, you're generally going to spend for an individual in the $4,000 to $6,000 range. That's going to be your range for a living trust plan.
One more, and I should say before this, that some people are asking if there will be a recording posted of this webinar, and the answer is yes.
Nope. No, if you didn't see it live, forget it. No, I'm sure it's going to be posted somewhere.
Actually, a couple more questions are coming in, but for now, what if you live in a co-op and you have Medicaid? How can my children keep the co-op and not have to pay back all the money Medicaid has spent on
Well,
me?
clearly you don't live in Columbia County because we don't have any co-ops in Columbia County or Albany County or most of the upstate counties. White Plains, Westchester has some, but mostly they're New York City creations in the 5 boroughs. I have a client in Buffalo that has a co-op. And for those of you that aren't familiar with co-ops, it isn't owning real estate. What you own with a co-op is a stock certificate because you're buying shares in the building and a proprietary lease. And we are successful in almost all cases today at going to the co-op board and having them transfer your stock certificate and your proprietary lease into a trust. Revocable trust, almost every co-op board today will accept, with some exceptions. Remember, co-op boards are people, and people have their own idiosyncrasies, and some people are persnickety about how they run their co-op. But most today will accept it because so many people today are doing trusts that we go to some co-ops and half the board have their co-op in a trust. And revocable trusts are easy. Irrevocable trusts, we have to do a little more work. And typically you have to put provisions, special provisions into the trust, which we do on a regular basis. We do a lot of co-op work in the city. And you can get those into your irrevocable trust too, provided you have the right documentation and language in your trust to deal with the co-op. Co-op boards are designed to be very protective of the building and to have control over who is the next resident, who is the next owner, and that all has to go into the documents. But provided you do that, you should be able to do it through your trust.
That's it.
All right, those are all the questions we have.
I think Jim's going to come back on.
I hope we see you all on March 25th. A lot of things changing in the tax world, very volatile tax policy right now. It's going to be up for debate after the stimulus bill, after probably the infrastructure and the ability to rebuild. Then they're going to tackle the tax policy, because sooner or later, as they keep spending 1.9 trillion and 2 trillion, sooner or later somebody's got to pay for it. So the tax bill, we think, is going to come up probably in the second half of the year.
Well, Lou, I just want to thank you so much for donating your time tonight to do this for us. I found it very informative, and I honestly can't wait for the next session.
Thanks, Jim.
Yep,
Yeah.
thank you.
Appreciate
Lou.
that.
Yeah. My eye
Thank you.
when I don't tell the truth, but it's not twitching. I'd also like to take this opportunity to thank Barbara, also Gina Orlando at the foundation, and Beth Wertman and Tim Flynn at Pierro, Connor, and Strauss, who've worked hard to put the series together. So thank you very much. To our attendees here tonight, thank you for joining us tonight. Hope to find you here during our the second part of the series. And just be well, please, and good night.
Stay safe.
Yes, thank you so much. Have a good night.
Thank you.
Bye-bye.
Bye.